Complete justice is not only the dream of the Constitution, but it is an ideal up to what level this statement is true. Complete justice Complete justice is not only the dream of the Constitution, but it is an ideal up to what level this statement is true. Complete is not only the dream of the Constitution, but is up to what level this statement is true. अन्याय करना यह हमारा दुश्मन है। न्यायाधीश को भी दंड देना धर्म है। India is always a country of justice. Justice is famous. Justice is an example. This is two worlds. In the past, family and social disputes were being settled by mutual understanding. Some reputed communities at Chopal of village. It was part of Panch Parmeshwar. Injustice is always to tolerate injustice has been treated as sin. Draupadi promised to take revenge of her father. It has also been Yadar was जनों को दंड मिलना चाहिए। समुचित सदा वर वीर कर्तव्य है सर्वदा। Not only this, our justice was fair and free. There was no place. There was no partiality in our justice system. पक्षपात, निरपेक्ष, कार्यान्वी, चौपंचवे, द्वेषा, वादी, राजनीति. That is, an impartial justice should be done by and just having free from any fear. Our today's justice also suffered from the same kind. Here it is expected from the judge in adjudication for the principles of natural justice and of equality, just and good conscience. In our present system, no person can be judged on case. Even after in our system, a concept of complete justice has been The justice and such which can remove whole pain and distress of the person. Here, one more not only the justice is to be made, but it is here, meaning thereby that there should be complete transparency in justice. There should be transparency in the justice. No such conduct given by the judge so that the person may not feel that injustice has been done. The judge should not make confidential talks with the party, should not take steps for hearing in solitude, should not pass secret. We may say in words the justice made by the justice should be complete justice. There is one more. Many times due to strictness of law, justice is not made incomplete justice. In the past, then the court of equity or chancery court was competing with lacuna. The court of equity was interfering in such cases where the was available in common law or such treatment was not agreed. In such cases, the court of equity attempts to provide complete justice. Base of this was to be just medium. Any Maleficent was not there for treatment. In the present justice system, complete justice has been given importance. Our judicial process also alive to that. The concept the concept of complete justice has been mentioned in Article 142 of the Constitution. According to it, the Supreme Court has its jurisdiction may pass such decree or make such order as necessary for doing complete justice in any cause or matter pending before it, and any decree so passed or orders so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provision you have in that behalf is so made in such manner as the present made by order prescribed, subject to the provisions of any law made by order made in this behalf by Parliament. The Supreme Court shall respect the whole of the territory of India, have all and every power order for the purpose of securing the attendance of any person, the discovery or production of any documents, or the investigation or punishment of any contempt of itself. From the above, that for complete justice, the Supreme Court may pass any decree or make order. In the case of N. Muskan Sahib versus Chief Commissioner Area 1963 have passed decree or make an order by cause in any cause or matter pending before it, and first order or decree is enforceable throughout the territory of India. But it is necessary that such decree or order should be in accordance with the fundamental rights guaranteed under the Constitution and provisions of relevant statutory of law. Premchandra Garg, Commissioner India 1963 FC 996, it is also to be mentioned here that this power cannot be utilized in such cases where the alternate treatment is available. Union of India versus Srimati Darshana Devi, Area 1997 SC 166. In the case of KM Nanavati versus State of Mumbai, Area SC 112, it has been propounded by the Supreme Court that when a such case is under consideration with the Supreme Court up to that period, the government can also not suspend the punishment of the accused under Article 16. In the case of B.N. Nagar from Mysore area 1996, SC 1940 by the Supreme Court that the benefit of order passed in appeal can also be extended to such persons who have not filed appeal. The case of Leela Devi, in the case of Leela Devi, Maharashtra AIR, in 272, it has been decided by the Supreme Court. The principle of complete justice has been predicated in Article 142. But the constitutional provisions should not be overlooked by the court in shelter of it. In particular, we said that the Article 1 is to find ends of justice. This is the reason it is binding to all courts. Rocky Coyles, Chandigarh versus Ajit Jain, AIR 1998, Punjab and Haryana, 2002, in the case of Imtiaz versus State of Uttar Pradesh, AIR 2012, SC 642. It has been held by the Supreme Court that powers of the court to seek investigation or trial of criminal case is extraordinary. It should be exercised with due care. Use of such power carries the responsibility to expeditiously dispose of this Supreme Court trial court to cases as possible perfectly, preferably within 6 months from date of order. Powers of court to exercise the powers following powers delegated to the Supreme Court. For the discovery of any document, for the investigation or punishment of any contempt of itself, attendance of persons to exercise the power in Article 142, the Supreme Court may make an order for securing the attendance of the person. For securing such attendance, someone will be issued under Order 5 Procedure 1908. Various kinds of someone has been shown as service in person, service by registered post, by pasting and prints, service by publication in newspaper, service by speed post, service by courier service, service by fax, message, etc. In the case of R.K. Sharma versus Ashok Kumar, in AIR 2005 Delhi, rules are under 72. It has been held by the Delhi Supreme Court that service of someone should be in person. If it is not possible, then service can be made by any other member of the assembly or by showing an evidence. This copy and production of documents under the Code of Civil Procedure 1908 provisions are made for document discovery and production at any time or at any level, and order to person or party will be made by the party to submit a document. Punishment for contempt. The Supreme Court has been declared as court of regard under Article 129 of the Constitution, and powers are delegated to him to punish the person of contempt of itself. Provisions for punishment for contempt of the court have also been made under the Contempt of Court Act 1971. Speedy trial and justice is fundamental right of person. Comment statement. Delay justice is a well-known formula. This formula given an indication that there will not be unnecessary delay in the justice. Delay makes justice meaningless if the justice is not made available to the suffered person in time. Then the justice becomes null and void for him. Each person justice available to him in time, and it is the reason the concept of speedy justice has been made in judicial administration. It will not be outdated and justice is too delayed. The cases are not for so long time. It is being said that the plaintiff does, but stool means important. That is, stool by and that is received by someone but lose their mind attending the court again and again. The justice looks like a miracle. There is a general public has losing belief in the court. Persons do not like to come to court. At the last present of delayed draw attention of legislation and judiciary. Many laws have been for city and civil justice are made time limit right from the institution soon to declaration of decision was fixed. Acceptance of time has been restricted. Later on, civil justice has been considered a fundamental right. Today, the civil justice is being treated as every part of life, the liberty under Article 21 of the Constitution. In the case of Singh ML versus of Jammu and Kashmir AIR 1986 SC 464, it has been stated by the Supreme Court, life and personal liberty is limited to legal illegal. Its court has been extended up to speedy trial and justice. Now is respected for speedy trial and justice. State versus Maksudan Singh, AIR 1996, Patna 38. The scope of Article 2 does not end at is such an umbrella which protects the investigation in trial and also there Surya Narayan versus State of Bihar case 57 Patna 20 290. Now this is being presumed that objection of long time in investigation and trial is not justifiable. Now it is expected that the trial and investigation should be fair and speedy trial includes investigation. In the case of Nirmal Singh Kahlon versus State of Punjab, 2009, it has been stated that the right to speedy investigation and speedy trial is not only to the accused. Right to speedy trial is also available to the victim of crime. The case of Santosh Dey versus Arunachal Pradesh versus Aruchana Guha, AIR 1994 FC 1229, it has been propounded by the Supreme Court that a trial unnecessarily continuing up to 14 years against the alleged of misappropriation of government money is breach of fundamental rights of life and personal liberty. In the case of Rajendra Singh versus Prem, AIR 2007 SC 3000, it has been decided by the Supreme Court that people are judiciary to authorities directly people urgently to ensure speedy responsible and right to speedy trial is a fundamental right. A plaintiff cannot be allowed to keep pending a case for uncertain time. In the case of State of Kerala versus Meek, AIR 2011 and 340, it has been cleared by the Supreme Court that right to free trial is a fundamental right. It granting bail, delay in considering trial is important factor. It should be taken into consideration in the case of Vakil Prasad Singh versus State of Bihar, AIR 2009 SC 1872, it has been stated by the Supreme Court that speedy trial and speedy investigation is fundamental right of the accused. A Here's investigation is one in the case of R.D. Upadhyay versus State of Andhra Pradesh 2007 as 6 it has been propounded that the Supreme Court that such person should be listed who are for long time and the trial is continuing. Also, it is necessary for fair trial that fair is required for safety of interest of accused and public interest. There, the hearing of cases should be done in closed doors. Vinay Narayan Prosecution of India EIR 889 in the case of Josephen Hirabhai Josephen Haribhai versus Narayan Bhai K. Kabai 2005 NOC 74 it has been stated by the Gurgaon High Court that continuance of trial for a long time due to vacant for a long time in the court and tribunals is that is not justifiable. It is violation of every kind of person. Such vacant are required to be filled in the immediately. In the case of Imtiaz versus State of Uttar Pradesh area 2012 as 642, it has been stated by the Supreme Court that long delay in delivery of justice violates the law. It has adverse impact on common man's access to justice. Law Commission should submit its recommendation on measures to be taken to ensure timely justice. It is necessary for speedy trial. In this manner, our judiciary has shown its interest in speedy trial and finalization of the cases from time to time. Speedy trial of the case takes time. There is not only one reason but so many reasons of delay. Government, administration, advocates, party, and today's justice system, all is equally difficult. And following reasons of delay in the justice, numbers of the two numbers of cases, the first is not is huge number of pending cases. The cases are published obtained total 2.12 crore cases up to 39 were under consideration in the courts of the country, out of which 52,500 cases in the Supreme Court, 40.17 lakh cases in the High Court, and 2.71 crore cases in various state courts are pending. Rajasthan Constitution of 23rd August 2009, the number of cases is increasing continuously of judges. The second main reason of delay in justice is vacant post of justice in various courts. Number of judges is not in that ratio in that Russian in which the cases increasing as per data obtained. Post of judges in the Supreme Court, 234 posts in High Court, and 18% posts in subordinate courts are vacant up to 31 March. Out of 6,946 sanctioned posts, 2,736 posts are in the country. Rajasthan Patrika Udaipur edition of the date 23rd August 2009. In this way, vacancy of 2 post offices adversely affects laws are being made and not for realization of the cases derived from the burden of being made of the existing courts. This of delay in trial and prosecution, complex process, and reason of decreased justice complexity in judicial process. Our judicial process is so complex that it do not go further quickly. The procedure is the civil procedure, the code of criminal procedure, the evidence etc. are presented with technical by misuse of that trial. Tendency of adjustment. One reason of delay in trial is increasing trend of adjournment. Many advocates seek of adjournment merely to delay. Even after amendment is issued code of procedure, the advocates become also to seek more free adjournment access holidays. The holidays in respect of courts are also excessive. Approach half of the year about as song holidays. Series of holidays is very long. Budgeted holidays, special leave, casual leave, privilege leave, restricted holiday, summer vacation, winter vacation, sick leave, etc. Due to these holidays, the working days are too less. In addition to the above, the apathy of government is also a main reason of justice today party, advocate, witness and general public and this passion for the witness and public accord even after issuing summons and warrant. These are also crucial. In this situation, delaying justice is natural. These are the main reasons for delaying justice. Suggestion. It is necessary for avoiding delayed justice or for speedy justice. For court should be placed in the absence of the case. Second, courts of justice should be paid immediately. Special courts should be established laws of specific nature for finalization of disputes that tendencies like law reconciliation agencies. Meaning should be motivated, judicial procedures should be free from complexity, laws should be simplified, efforts should be made to avoid for administration in justice, organization courts should be concealed, judgment should be increased, judicial management should be improved. I would like to thank all my ladies and gentlemen, students, scholars, teachers, professors, professionals, listeners, learners. I would like to thank respected doctors and directors. I would like to thank adorable managers and from the advocates, advertiser, administrative advisors, the most honorable present person. Thank you very much. Have a nice. Thank you. Proceed.